Does the judicial system favor custody of children to the woman? What is the judge's decision based upon? Good question. And generally, yes, although the gratuitous and sexually discriminatory practice of indulging a default preference for the mother or woman has steadily weakened substantially over the last 40 years and counting, more and more jurisdictions are adopting a presumption that joint physical custody of the children will be awarded unless it can be shown by a preponderance of the evidence we should examine here. That means that the evidence shows it's more likely than not that a claim is true. So unless it can be shown by a preponderance of evidence that joint physical custody is not in the child's best interest, it will usually, but not always, mean that a parent has been shown unfit to exercise joint physical custody. Every jurisdiction has a list of factors it requires the courts to consider, and most of those factors are the same, though each jurisdiction may value some factors more than it does others, or put more emphasis on one more than the other. Here is the list of factors Utah requires a court to consider when determining whether the child custody award will be a sole custody award or a joint custody award. Some factors in some sections of the Utah Code overlap with others, so where they do, I will only mention them once. Buckle up, it's a very long list. Utah Code Section 30-3-10, entitled Custody of a Child, Custody Factors. Here are the factors. Evidence of domestic violence, neglect, physical abuse, sexual abuse, or emotional abuse involving the child, the parent, or a household member of the parent. The parent's demonstrated understanding of, responsiveness to, and ability to meet the developmental needs of the child, including the child's physical needs, emotional needs, educational needs, medical needs, and any special needs. Other factors, the parent's capacity and willingness to function as a parent, including parenting skills, co-parenting skills, including ability to appropriately communicate with the other parent, ability to encourage the sharing of love and affection, and willingness to allow frequent and continuous contact between the child and the other parent, except that if the court determines that the parent is acting to protect the child from domestic violence, neglect, or abuse, the parent's protective actions may be taken into consideration. Ability to provide personal care rather than surrogate care. Other factors, the past conduct and demonstrated moral character of the parent, the emotional stability of the parent, the parent's inability to function as a parent because of drug abuse, excessive drinking, or other causes. Whether the parent has intentionally exposed the child to pornography or material harmful to minors, as material and harmful to minors are defined in Section 76-10-1201 of the Utah Code. Other factors, the parent's reasons for having relinquished custody of parent time or custody in the past, duration and depth of desire for custody or parent time, the parent's religious compatibility with the child, the parent's financial responsibility, the child's interaction and relationship with step-parents, extended family members, or other individuals who may significantly affect the child's best interest. Who has been the primary caretaker of the child? Previous parenting arrangements in which the child has been happy and well-adjusted in the home, school, and community. The relative benefit of keeping siblings together. The stated wishes and concerns of the child, taking into consideration the child's cognitive ability and emotional maturity. The relative strength of the child's bond with the parent, meaning the depth, quality, and nature of the relationship between the parent and the child, and any other factor the court finds relevant. 30-3-10.2 of the Utah Code is entitled Joint Custody Orders, Factors for the Court's Determination. These factors include whether the physical, psychological, and emotional needs and development of the child will benefit from joint legal custody or joint physical custody or both, the ability of the parents to give first priority to the welfare of the child and reach shared decisions in the child's best interest, co-parenting skills, whether both parents participated in raising the child before the divorce, the geographical proximity of the homes of the parents, the preference of the child if the child is of sufficient age and capacity to reason so as to form an intelligent preference as to joint legal custody or joint physical custody, or both. the maturity of the parents and their willingness and ability to protect the child from conflict that may arise between the parents, the past and present ability of the parents to cooperate with each other and make decisions jointly. 30-3-35.2 is the equal parent time schedule factors. A court may order an equal parent time schedule described in this section if the court determines that, first, the equal parent time schedule is in the child's best interest. Next, each parent has been actively involved in the child's life, and each parent can effectively facilitate the equal parent time schedule. To determine whether each parent has been actively involved in the child's life, the court shall consider each parent's demonstrated responsibility in caring for the child, each parent's involvement in child care, each parent's presence or volunteer efforts in the child's school and at extracurricular activities, each parent's assistance with the child's homework, each parent's involvement in preparation of meals, bath time, and bedtime for the child, each parent's bond with the child, and any other factor the court considers relevant. To determine whether each parent can effectively facilitate the equal parent time schedule, the court shall consider the geographic distance between the residence of each parent and the distance between each residence and the child's school, each parent's ability to assist with the child's after-school care, the health of the child and each parent consistent with Utah Code subsection 30-3-10 sub 6, the flexibility of each parent's employment or other schedule, each parent's ability to provide appropriate playtime with the child, each parent's history and ability to implement a flexible schedule for the child, physical facilities of each parent's residence, and any other factor the court considers relevant. 30-3-32 are parent time definitions and considerations for parent time and relocation. A court may consider the following when ordering a parent time schedule: whether parent time would endanger the child's physical health or mental health or significantly impair the child's emotional development, evidence of domestic violence, neglect, physical abuse, sexual abuse, or emotional abuse involving the child, a parent, or a household member of the parent, the distance between the residency of the child and the non-custodial parent. A credible allegation of child abuse has been made. The lack of demonstrated parenting skills without safeguards to ensure the child's well-being during parent time. The financial inability of the non-custodial parent to provide adequate food and shelter for the child during periods of parent time. The preference of the child if the court determines the child is of sufficient maturity. The incarceration of the non-custodial parent in a county jail, secure youth corrections facility, or an adult corrections facility. Shared interests between the child and the non-custodial parent. The involvement or lack of involvement of the non-custodial parent in the school, community, religious, or other related activities of the child. The availability of the non-custodial parent to care for the child when the custodial parent is unavailable to do so because of work or other circumstances. A substantial and chronic pattern of missing, canceling, or denying regularly scheduled parent time. The minimal duration of and lack of significant bonding in the parent's relationship before the conception of the child. The parent time schedule of siblings, if any. The lack of reasonable alternatives to the needs of a nursing child, and any other criteria the court determines relevant to the best interest of the child.